La Cour
asserted that while being Minister of Interior from December 2007 to January 2010, the applicant unlawfully arranged for different work-related benefits for his driver. And under this case, the applicant was suspected for allowing unlawful requests for his subordinates on continuation of applying special investigative measures. Thus, answering the question concerning Article 5 of the Convention, it is important to emphasize that the applicant's arrest on the 26th of December 2010 was performed within frames of the second criminal proceedings. Hence, it is beyond any doubt that at the moment of the applicant's arrest, national authorities had sufficient information which, as it is required by the court's case law, would satisfy an objective observer that the applicant might have committed an offence. First of all, on the 27th of December 2010, the applicant was brought before a judge with the purpose of choosing him preventive measure within frames of the first criminal proceedings. Due to the fact that court's decision ordering detention of the applicant was issued within frames of the first criminal proceedings, it was inexpedient and pointless to choose one more preventive measure within frames of the second criminal proceedings, as being in detention on remand, the applicant in no way could obstruct investigation or evade justice. The applicant had all necessary facilities to challenge the lawfulness of his detention on 26 December 2010, as well as enforceable right to compensation if the court found that the arrest had been unlawful. In spite of this, the applicant did not challenge the lawfulness of his arrest. First of all, the courts of two instances, which considered the applicant's case, found several reasons for detention of the applicant, the most important of which was potential risk of putting pressure on witnesses in the case. Consequently, Honourable Court, the government of Ukraine consider that in the present case, arrest of the applicant and court's decision about his detention complied with requirements of Article 5 of the Convention. Supporting the aforementioned position, the government of Ukraine consider that the applicant's arrest on the 26th of December 2010 was based on reasonable suspicion of the applicants committing a crime. The government of Ukraine consider that the applicant's detention on remand was based on the necessity of receiving proper testimonies within frames of the criminal proceedings, including the necessity of receiving those testimonies by the court.
Thank you very much, Ms. Lutkowska. I call Mr. Igor Fomin.
The government agent says that he was apprehended on another criminal case, but did he know about that? Did his defense know about that? We know that the new criminal case against Mr. Lutsenko, but we know that only now, was instituted by the Prosecutor General's Office of Ukraine on Friday. In other words, a day before that weekend, on the 24th of December. And our investigation had already been completed, because the law in general does not make it possible to do any investigation actions after pre-trial investigation had been completed and after Gator rejected my request. The following day, at 9 a.m., that was Monday, at 9:15, I was called by the same investigator who told me that in 30 minutes the court will start hearing the case of Mr. Lutsenko's arrest. Tell me, please, the government now says and tells this High Court that we had the possibility to get ready for that hearing. How could I have done it? I only had 15 minutes of my working time. The preventive measure within the framework of the old criminal case. So we could not even give the court all the evidence, all the documents to the court, which would speak about his state of health, his financial state, his family state, all the documents that the court is to study as it makes decision on restricting one's freedom and detaining one on remand. I would also like to draw the attention of this High Court that Yuri Lutsenko was arrested because he was complying with his constitutional rights, the right not to testify against oneself, which is very clearly indicated in the court's decision, the right not to plead guilty, not to admit one's guilt, and its criminal procedural right to which one can study the materials of the case. I would like to draw your attention to the fact that the grounds on which Yuri Lutsenko was arrested were not only unlawful, not only the ones that do not comply with the Convention on Basic Human Rights and Freedoms, but they're directly in conflict, unlike Mr. Lutsenko. I would also like to draw your attention to the fact of alleged pressure upon the witnesses. How could the defense or Mr. Lutsenko could press the witnesses if he didn't even know who they were? We had only started studying the cases, the materials of the case, and the Prosecutor General's office. Now, as to the fact that Mr. Lutsenko had a possibility, as the government agent said, had a possibility to commit new offenses, well, we have to understand what refers to his driver. Tell me, please, how Yuri Lutsenko could continue his criminal activities if he had not been Minister of the Interior for 2 years. I will ask this court, I will tell you what Mr. Lutsenko said. Mr. Lutsenko said that today in Ukraine there is only one court that the people of Ukraine confide in, and that's your court, sir.
Thank you very much, Mr. Fomin.
My question concerns the consultation of the case file. Is there an obligation under Ukrainian law to consult the case file? How does the allegedly incomplete consultation of the case file hinder the criminal investigation? And is it a general practice in Ukraine to sanction a person who incompletely consults the case file? When was the applicant brought before a judge according to Article 5, Paragraph 3? Namely, where a judge told him, first, the offence of which he was suspected, and second, where he could explain himself. My question, in the present case, in view of these guarantees, was an alternative preventive measure for the applicant adequately considered? Thank you.
The government have pleaded that the arrest was based on the allegation that Mr. Lutsenko had put pressure on the witnesses. I just want to understand how you define the word pressure.
Were these additional investigative actions conducted in respect of the first criminal case against the applicant, or they concerned other criminal cases instituted against him and later joined to the first case? Could you please specify when exactly Mr. Lutsenko himself was informed or in other way found out that he had been arrested on 26 December 2010 in the framework of the second criminal case instituted against him? Thank you.
Thank you very much. Judge Yudkivska, please.
All further investigative actions were conducted within frames of new consolidated criminal proceedings. The applicant was detained because of existence of grounded suspicions on possibility to put pressure on witnesses. Due to the aforementioned fact justifying the applicant's detention, the other preventive measure could not ensure the applicant's proper procedural behavior. Thus, such preventive measures, like a bail or a deposit, could not have removed potential risk of putting pressure on witnesses.
The first question was about Article 218 of the Code of Criminal Procedures of Ukraine, which suggests not a duty but the right of the accused to consult the case file after the pretrial investigation is over. In case of the accused takes too much time with studying one's case, only the court can restrict the time allocated to studying the case file. Second question was... Thank you.
Thank you very much. We have now come to the end of the hearing. I thank the parties for their interventions and answers to the court's questions. The court will now deliberate on the admissibility and merits. The judgment will be delivered later. The parties will be informed of the date of delivery. I declare the hearing closed.